Licensing, prepared for and presented at the 2016 Square One Entrepreneurship Training Program. Square One is a program of the Center for Emerging Technologies. CET is an affiliate of the Cortex Innovation Community. Square One is funded in part by the Missouri Technology Corporation.
Just want to kind of do some little introductory type questions, just kind of get a feel for the audience as to where you are in the process. Just generally speaking, just license agreements, is that something that's familiar with just by a show of hands, is that something familiar with you? And how many people would say that it's not really a familiar concept? Okay. All right, so at least about half the group is not real familiar with it. So let's just kind of from a very top level, kind of just address what licenses are. Licenses are a contract. And so it is a contract, it is a binding type contract. So basically what you're licensing is, it could be a technology, it could be the technology along with the intellectual property rights that are associated with it. And so you're allowing someone to make, use, sell, distribute, or import, export that particular thing that you're licensing, whether it be the technology or the product or the intellectual property that's surrounding it. So that, generally speaking, just from a top level, is what a license is. It is a contract and it is agreement between parties. And if I trip here, guys, promise not to laugh over this wire here, but it is a contract between parties and it is binding. So that's just in a general nature. So just think about it in the terms of a contract. So one of the things that I like to start off with always is to kind of give a top level view or introduction as to the types of things you should be thinking about when you're looking at a license. So again, it is a contract between parties. But one of the things that you should look at, it says, what is the nature of the deal? In other words, what is the nature of the deal that you're entering into? You need to look at that from a very top level perspective, because that oftentimes drives your decisions going down the path of entering into a license agreement. And so one of the things that you could possibly look at is for one thing, is to whether or not your license is something that is a regional license. In other words, it's a license to use, make, or sell a product in a particular region. Or it could be national, or it could be international. So what is the nature of the deal? Oftentimes you also look at it from the standpoint of, what is it you're specifically licensing? Are you just licensing the product or the technology, or are you also licensing the intellectual property that goes behind it as well? So that may change the nature of the deal. So you have to understand the nature of the deal. You have to also look at the parties that are involved. Are you looking at a distributor, right? Or are you looking at someone that is a possible, just a person that's going to be a marketing person that's going to sell your product? What exactly are you looking at? Are you looking at a manufacturer? What is the nature of the deal that you're looking at? Also, it may just be licensed to use. So you just may be using the technology. You may not actually be making it or selling it, right? You're just using it for your own purposes. One of the other things that we should look at also is who is bringing what to the table. And so what do I mean by that? When you're dealing with a contract, right, there are multiple parties that are involved, at least two, right, on either side of the contract. And so what are the parties bringing to the table? So what do you think I mean by that? What do the parties bring to the table? So for instance, as an example, if you're doing a license agreement, and let's say for instance you have a product that's to be manufactured, right? And so let's say, for instance, your type of product that you're interested in distributing is manufactured by a particular manufacturer that does that type of product all along. In addition to that, they may also have a distribution arrangement already with certain purchasers of that particular type of product, right? So what that person or that entity brings to the table is the ability to jump onto manufacturing very quickly, right? They also have the ability to distribute your product very quickly. So they're bringing that to bear as it relates to your technology, right? And so what are you bringing to the table? It may be a unique technology that solves a particular problem. So when you're entering into the license agreement, you have to understand who's bringing what to the table. And why is that important? Oftentimes that drives the cost. In other words, what it is that particular technology is worth, how much is the licensee willing to pay for that particular technology to distribute it or manufacture it or what have you. And it may be somewhat lopsided. In other words, it may be the manufacturer that really is bringing the weight to the table, because that manufacturer also has a huge international distribution chain, and so you may just get a small piece of that pie. In other words, the return on for each product that's sold, but it's so broad. In other words, the numbers are so huge that you take a very small royalty off of that particular product, each individual product that's sold. So who's bringing what to the table?
Mark, is there a typical range where one might expect royalties to be, or is it really dependent on the technology and the situation?
It depends on the technology and the situation. I mean, you know, obviously you'll hear people use a rule of thumb 3 to 5%. Well, you know, that's, you know, not necessarily true. Maybe for the average widget that may be true, but that's not necessarily true. And again, it depends on the situation. It depends on, again, who's bringing what to the table. Because again, if you're dealing with a distributor or a manufacturer that has international reach, right? And if you're accepting the 1 or 2% range, that could be huge, as opposed to doing a deal with a manufacturer who has a very local reach, right? Because the numbers of the volume is going to be astronomically different. And so it ranges. And there are different sources that you can tap into that will give you at least a metric that you can use to determine, for a given technology, for the given space that you're in, what is a typical or average royalty arrangement. Okay? Who stands to profit the most, right? So oftentimes when you're doing your license agreement or doing the deal, you need to ask yourself the question, who stands to profit the most? And oftentimes what you're bringing to the table, right? In other words, you're going to profit the most, and their manufacturer may not need your product, right? In other words, it's going to be a blip, a very small blip on their radar as it relates to that. So who has the most to gain, right? Who stands to profit the most? If there's no license, what are the alternatives? So for instance, as an example, you may be the person who is developing a widget, but in order for you to actually produce and distribute that widget, you may need a license in order to do that, because there may be someone who has intellectual property rights surrounding that particular technology. And so you may have to take a license in order to do that, or you may be licensing to others. And so one of the things that you have to look and weigh and balance is, what are the other alternatives to that particular product or technology? In other words, are there some non-infringing alternatives that are available? So if there are other non-infringing alternatives that are available, then what does that do to the product, the value of the product? It reduces the value of the product, right? So if there are other alternatives that are out there, that reduces the value of the product. So again, what is the nature of the deal? What is it that you're looking at? What are some things to watch when you're just dealing or negotiating a license agreement? These are some major sections of what you will see in just about every license agreement, are some things that you need to be concerned about when you're doing that review process. Now, obviously, when you negotiate a license agreement, you should have an attorney represent you in that regard. So I'm not suggesting that you go this on your own. However, it is always pays. That attorney can assist you much better the more educated you are. So here are some things that you should look at. One of which is just the grant clause. And the grant clause is nothing more than simply saying, this is what I'm granting to someone else. I'm giving a person the rights to do something, right? So that's your grant clause. And you have to be careful about that, and we'll deal with that a little bit later. Limitations on use. We kind of talked about that a little bit already, right? In other words, it may be regional, right? So I say you can distribute or sell my particular product, but only in the United States. Or you can only sell it in a particular market. Or you can only sell it to these particular types of retailers. So there may be limitations on use of the technology. Term and termination, in other words, how long does the license go for? In other words, is it a year, 2 years? What's the term? And how do you go about terminating the license if you want to terminate it? What are the royalties? We already had a question on the royalties. It could be a fixed fee as opposed to a royalty-based agreement. You may just have a fixed fee that says that I will pay X dollars in order to use your technology for this particular period of time, right? So it may be fixed fee. Reporting and accounting requirements. There's always reporting and accounting. If you're licensing the technology or you're licensing someone else's technology, there's usually a reporting requirement on behalf of the licensee where you have to tell them what it is that you're selling. Why? Because oftentimes there's a royalty associated with that, or there may be other criteria that's associated with the agreement that you have to do a reporting to the licensor, the one that owns the technology. Quality control, you always be concerned about that, right? Because that product oftentimes carries your brand. So you want to make sure that product is being delivered in a very quality manner, right? Yes?
Just a general question, maybe this is too early, but take Gore-Tex, right?
Take what now?
Gore-Tex, Gore-Tex. So Gore-Tex is it's a membrane that basically does not allow moisture, but allows air to flow through. So it's in coats and it's in shoes, right? So it's breathable, which is great, but it's also waterproof.
Okay.
What they do is they have certain select manufacturers who they license the technology to, but they don't sell to them. They sell to the below a boot company or the Arc'teryx coat company, and they say, I'm going to get a royalty from the manufacturer because it's an OEM product, and I'm going to have a licensing agreement with the manufacturer. How do you think about that? Because the alternative to that is to say, okay, Arc'teryx coats, which is a high quality coat, I'm going to do a tech transfer, and here's the formula for Vortex, and you get to make it, but you have no quality control as opposed to controlling it with the licensee, who's the manufacturer. So it's a royalty and a license agreement.
Right, right. So that's a great question, and the reason why that model works very well, particularly for ones that have a particular brand that they have a brand that they're trying to protect. And so they want to have some level of control. They don't want to just turn the technology over to someone else and then have that technology be utilized. And
winter coat or a boot is going to be a totally different construction.
Right. And so they want to maintain some level of control or in that process. And so by having approved manufacturers who are licensed to do the technology, they maintain a certain level of control. It carries their brand, and it maintains that brand over time. So that model is very popular, and it's a very good model that tends to work very well. And so to answer your question, I do like that model.
Well, the Vortex patents have got to be something like 40 years old. So when is it they're actually contracting with? Because the patent is only good, at the time I think it was 17 years, and now it's 20.
Right. So oftentimes what you'll find with patented technology is that there are also a lot of know-how that goes behind it, right? And so even though what you see on the face of the patent has a certain term limit to it, there may be all kinds of trade secrets that are also as it relates to that particular manufacturer. So for instance, as an example, a particular product may have, let's say for instance that you could have a patent that protects the membrane nature of the product that says that it can allow certain things to pass through and other things not, right? Well, in order to manufacture that effectively, there may be certain processes or proprietary processes in order to do that. And there's any number of products that are like that, whether it be LCD displays as an example, right? There's only like a few LCD manufacturers in the whole world that produces for your cell phones, for your television, your flat screen television, et cetera, because there's a lot of know-how, there's a lot of published information about it, but there's also a lot of know-how behind the scenes in order to really do it effectively and have the type of yield that you need and the quality control that you need. So there's sometimes other technology behind the scenes that you may not necessarily see. And so there still could be an ongoing license agreement to say that we will give you that secret sauce, if you will, that's not in the patent literature. That makes sense? Okay, all right. Does that answer your question then? Okay, so.
So Mark, you're saying you can license the technology, the product, or the process, right? Is that what you're saying?
There are pieces of the pie, right? So you may license the technology or the product, right? And we'll cover that a little bit in a later slide, but you also may license the underlying intellectual property behind it, whether it be your IP rights, your patent rights, or your trade secrets, or your know-how, et cetera. So there are other...
Actually how to process a product, right?
Exactly. Yeah, so there's different pieces to the pie. It's not always, you don't necessarily license everything at one time. We'll talk about that a little bit and some of the problems that it causes. Okay? Okay, so here's some obstacles, and we're going to get to some of these other questions a little bit later down the line. But one of the things that I always like to try to cover, particularly as it relates to patented technology, because we oftentimes think about patented type technology. If there are joint owners, because oftentimes there's more than one inventor, right? And under U.S. law, if you have two inventors, they jointly and severally own their technology, right? By definition, unless they otherwise assign it to someone else, right? And so if you have joint ownership, each owner can exploit without the permission of the other. So they don't have to get the permission of the other person to exploit it, right? So if you have joint inventors, then they can independently exploit, and they have no duty to share the royalties at all, right? A little bit different with copyright and some of the other intellectual property rights, but as it relates to patented technology, they have no duty to share those royalties, unless there's some agreement that's in place that dictates so, okay? So that's important to understand. Also, when you're looking at enforcement in the U.S., oh, I'm sorry, you got a question?
So if there's two inventors named And let's say there's no communication between the two of them. They just invented the thing.
Invented independently, or they work
They
together?
invented it together.
Okay.
They filed the patent together, and then no more do they talk to each other. Now this guy over here, or girl, whatever, whomever over here says, fine, I'm going to sell the exclusive rights to doing this to XYZ factory. And this person over here says, or doesn't know that it happens. But you can't sell the exclusive rights because you don't have the exclusive right to pursue it. Because I can go over here and sell the exclusive rights, and then we have to get the exclusive rights.
Right. Correct.
How does that get stopped from happening?
Well, hopefully you seek counsel, but basically what in that scenario, if a person were to issue what is supposedly, allegedly exclusive license to an entity, then it really isn't exclusive. And they haven't disclosed properly to that licensee that they don't have exclusive rights. And they should have disclosed that during the negotiations of the license. So from that standpoint, that's certainly a potential lawsuit that could ensue as a result, right?
So the lawyer on the other end would say, hey, there's another inventor. We don't
Yeah, you didn't tell me about it. You didn't disclose this. You said you had all rights, title, and interest in the ability to grant me a full license, exclusive license, this thing, but you really didn't, right? And so if there's some damage that's caused as a result of that, there could be potentially a lawsuit that ensues. Okay. All right. So the enforcement piece. In other words, you don't have the ability oftentimes to even enforce, right? Because if that other person is out there doing exactly what you're saying, right? Then they have the ability to independently exploit that technology without the other's permission. So a possible solution to these is that you can have some type of contractual allocation of rights, whether it be the rights to sue, assignment of rights to the other party, and et cetera. So you can contractually solve that, as well as one of the potential structures that you can go with is that you can have an assignment with a license back. So for instance, there are two parties that are involved, and they say, hey, I'll assign all my rights to you, but you just allow me to use it just for my own purposes, right? In other words, I'm not going to disparage your rights in any other way. I just want to use it internally for my own purposes. And so there's a possibility that could transpire as well. Okay. So some other licensing obstacles. So when we look at it from the standpoint of technology, and this kind of addresses the question that was asked earlier, right? Oftentimes when we look at a license agreement and we look at the grant clause, in other words, what are we granting the rights to, right? And so oftentimes in a license agreement, you're granting rights to technology. So you use this generic term technology. You oftentimes see this in a license agreement. So the question becomes, what does that really mean? When I grant rights to a technology, what am I saying? Am I granting rights just to the product and the processes or the know-how? Or am I also granting rights to the underlying intellectual property, right? Completely different things. And you don't necessarily have to grant rights to anything other than the product. Because I think the question earlier was, there can be the process part of it as well, right? In other words, how do you go about manufacturing it? Or how do you go about, using it in a proprietary way? So there are different parts to the puzzle, and you have to make sure you're granting exactly what it is that you want to grant rights to. So using a general term like technology, and if you define that term very generically, you may be granting something that you don't want to grant, all right? And so you want to be careful in that regard. So what are some examples? So if you have a technology defined as a product, deliverable, and patent rights, right? Then in your grant clause, if you grant technology, you're giving the right to practice not only that independent product or that deliverable, but you're also giving them the rights to produce their own product under that patent. So for instance, you have a particular widget that's covered by a patent, right? You grant the rights to that technology, and it's defined as that widget as well as the intellectual property that's underlying it, right? Let's say they take that intellectual property and produce a different widget, but it's also covered by those patent rights, or what you disclose in your patent, right? It may not be the exact same product. And so you've granted the rights for that person to do that as well, if under that definition. So now why does that cause you a problem? Sometimes it's as a result of an infringement issue, right? So if you give a person a warranty to say that if you utilize this license, right, this grant of this license, you utilize the technology that's been granted to you, right? In those cases, if you granted the intellectual property rights as well, those underlying products, if they produce something different than the product that you were intending to grant, and it infringes someone else's product, then guess what? You're still on the hook, because that's what you granted to them, and you indemnified them under that license agreement saying that you will indemnify them for any infringement, regardless of whether it's infringement of that as it relates to that particular product or as it relates to the intellectual property. Does that make sense? I think I had a question.
Yeah, so I've always heard of the term licensing and technology transfer as two different terms, right? So in my example, the Gore-Tex example, I license it to somebody who just manufactures it, and I control what they do. If I go straight to an OEM, let's say shoe manufacturer, that's who's not going to buy from them, I tech transfer, they make it however they want to make it. Is that the right way to think about that? Is that what you're right?
Well, technology transfer is kind of a broader term, right?
It's broader than licensing.
It's broader than because technology transfers can mean a lot of different things, right? As an example, a material transfer agreement could be, a potential technology transfer, right? In other words, we don't have the biotech folks in here, but if you have a particular biologic that you want to allow someone to do and use for research, right? Then that particular material transfer allows that person to do that, and then they have to return that biologic back to you, right? Okay. Whether it be in stem cell research or what have you. And so, so tech transfer is a very broad umbrella that can cover a lot of different things, right? It could be, even tech transfer could be in a joint research and development agreement, as an example, right? You may jointly decide you're going to do research and development, and you're going to transfer certain technologies during that process.
And so just a very, very general question. Licensing, you have presumably more control over the production and output than you do with the tech transfer, or is that not necessarily the case?
Well, again, I wouldn't necessarily even refer to it as a tech transfer agreement per se. Okay. There are a lot of things that are considered tech transfer, one of which is a license, right? A material transfer agreement is another type of tech transfer. It's just a subset.
It's a subset, okay.
Yeah.
That's helpful.
Does that make sense? Okay. Any other questions along those lines? So let's move on. I don't know how I'm doing with time. So licensing pitfalls. The grant clause doesn't convey what you want it to convey, right? And so we talked about that a little bit earlier. So what is it that you're really intending to grant? First of all, your grant clause has to be in writing. It has to be clearly in writing, clearly segregated out in your license agreement, right? And you want to make sure that that you have the entire rights, title, and interest in order to make that grant, right? So you don't grant it to, like the example that was used earlier, right? If you have joint inventors, right, and you want to grant someone an exclusive right, well, you don't have the exclusive right, so you can't do that. So you have to make sure that you understand what the grant clause is really saying. You may also want to have issues as it relates to limitations on use, limitations on right to assign or license, right? So for instance, if you have in your grant clause, you may want to define what limitations you want to apply. Like in this particular case, you know that you can't give an exclusive license, right? Because you have two joint inventors and you're acting independently, so you don't have the ability to do that. And so this exclusive license agreement, when you do have an exclusive license that's in play, first of all, the exclusivity can be based on geographic region, it can be based on field of use, and it may have a certain temporal term to it. So I can say, I'll give you the exclusive right to sell this particular product in Missouri. And you're the only one that can sell it in Missouri. And that can be an exclusive right. It can be a field of use. So I will allow you to sell this particular technology, but only in the stem cell research area, right? And the more clearly you define that, the better off you are. But you certainly want to avoid ambiguity and be very specific as it relates to what it is that you're granting. And so if you look at it from a spectrum standpoint, assignment of rights, so in other words, you're assigning everything in your grant clause, right? Versus an exclusive right versus a non-exclusive license, right? A non-exclusive license is saying you're licensing against someone, but you're not giving them the exclusive rights to make, use, or sell, or whatever the grant clause is. Does that make sense? Any questions on that?
Which one is better? Which one is better?
Well, it depends on, again, depends on what it is you're trying to achieve, right? Obviously, from a licensee's perspective, right? Oftentimes having an exclusive license is very beneficial because that gives them carves out a space for them that's very exclusive. They may not need an exclusive right, though, and they may not really want to pay the extra dollars that's associated with that, right? An assignment is basically you're assigning everything over to the person. Go ahead.
If you want to, if you want to carve out the license, so let's just say a good example is like in the toy industry, right? So Disney has pick your character, and they can assign licenses for figurines. They can do movie license. They can chop that license up into different ways. Do you have to proclaim that as all the possible chops ahead of time before you start granting? Or like you get down to it and you realize, hey, there's a 6-inch figurine, but there's a 4-inch figurine as well, and I'd like to give you the 6-inch, and now that I think of it, since I could give you the 4-inch and not them that, so, okay, now there's a 4-inch slice of it. How does that work? Do you have to kind of slice it all up to begin with and say there's the package and you're going to take part of it and that has to be known, you got to live within those rights?
Yeah, I mean, you need to think that through up front, obviously, right? Because, you know, if you grant something to a licensee, right, and then you can't now take away their rights later, right? So, for instance, if you give them the right to make that figurine and you don't specify the size or where it could be used or what have you, you can't later come back and say, hey, I only really meant the small ones. I didn't really mean the big ones, the life-size ones or whatever. And so you can't go back later and they certainly, at the end of that term, they may be willing to negotiate a different license agreement, but you can't go back and take someone's rights away as a result. Does that make sense? Okay, so let's move to the next slide. I don't want to run out of time here. Let's see, lack of planning for mergers and acquisitions. This is another pitfall that oftentimes happens, right? Obviously, as startup companies, you are what? Oftentimes you want to have an exit strategy, right? Or you may want to merge with another entity that may occur. There may be a benefit to you as a startup entity. Well, oftentimes when you structure your license agreements, you don't do them effectively such that it plans for that, right? Because oftentimes how that license agreement is structured can oftentimes be a pitfall or an obstacle for striking a deal, right? So for instance, as an example, if you have given an exclusive right to someone, right, and it is a very long term to it, and you have a potential buyer, but the reason why they're interested in your particular technology, right, is because they want to now take this item and sell it to someone else, distribute it in a different manner than what you've done before. But because you gave a general exclusive license to someone else, that has reduced the value and it doesn't allow them to achieve whatever goal it is that they're looking to achieve. So even though that exclusive right may seem to be, or that particular license arrangement that you struck for a particular field of use or for a particular region and what have you, may seem to be very sweet at that time, but you have to look at it from the standpoint, what is really going to be my ultimate exit strategy? What am I looking forward to ultimately as my ultimate goal as a company? And that license that you just struck may be an obstacle to you achieving that goal. So you have to use a little bit of a forecast to figure out where you are. Okay? So you have to make, and also with regards to license agreements, particularly licenses that you take on, right? Licenses that you take on, but also as in the position of a licensor, right? If I'm a licensor and I license to someone else, but then I want to sell my company, I have to have the ability as a licensor to assign those rights to someone else, the potential purchaser of my particular company. And if you haven't specifically called that out in your agreement, there may be some issues in that regard, right? So you want to make sure that you have the ability to assign rights. The other thing that you want to do as well is that, particularly as a licensor, is that you want to plan for any potential bankruptcy. So as an example, if you are licensing your technology to a manufacturer, as an example, or to a distributor, and that particular manufacturer or distributor goes bankrupt, right? And going back to the quality control issue, do you want a successor in that bankruptcy proceeding to now be able to take over that license agreement, right? And so oftentimes what you want to have in your license agreement is you want to have it structured in such a manner that if a bankruptcy does occur with that manufacturer or that distributor, then that license effectively terminates, right? And so you want to be careful in that regard because you may not want that successor to take over the relationship. Okay? Does that make sense? Any questions on that?
So would that be like an asset that would be seized by a creditor?
Possible.
The license itself?
Possible, yeah, and you certainly have the potential to do for that to occur. And so, like I say again, if you want to make sure that you control that relationship, because oftentimes it's the reason why you're entering into the relationship is because of the other person on the other side. In other words, the very first chart we talk about who's bringing what to the table, right? And if that distributor has an international reach, and that's the reason why you entered into that exclusive relationship with him, right? And then all of a sudden they go bankrupt, and then you have another player who has a much shorter reach as far as their reach of distribution is concerned, you may not want that deal anymore. Certainly not under those same terms, right? And so you want to make sure that you have the ability to terminate that in the case of a bankruptcy proceeding. Okay? Because you may end up with a deal that you don't really want. Another part that we covered on the first chart was reps and warranties. One of the big reps and warranties that oftentimes you'll find in a license agreement, and I really caution small companies, whether it be, startup companies or small companies in this regard as far as the reps and warranties, because one of the big things is the indemnification piece. And the indemnification oftentimes is saying that you're going to indemnify the licensee against any infringement actions. That's tough, right? Because if you are licensing your technology to someone and you're guaranteeing to that licensee that your product doesn't infringe someone else's patented technology, have you really done your diligence to make that rep and warranty, right? And do you really want to be hanging out there with the ability for someone to come after you for indemnification because you find out later that that particular product is in fact infringing someone else's patented rights?
So does normally the licensee take on that infringement risk? Normally?
Well, I shouldn't say normally. It's a negotiated term, right? And so the licensor, and I would say probably on average, the licensor does take on the licensor, the owner of the technology. Right, and so they're licensed. Oftentimes that's the case. Now, but again, in the case of a small company or a startup company, right? If you're looking at it from a large entity standpoint, as an example, right? In all practical terms, right? If I'm dealing with a startup company who's licensing me technology, and they give me an indemnification agreement, yeah, they do. But if I go after them, what am I going to really get? Right? I'm not going to get a lot, right? But from the standpoint of the startup's point of view, again, you don't want that liability hanging out there. And so all I'm saying is that you should have to be careful about negotiating those terms. You don't want someone coming after you with a lawsuit as a result of providing the indemnification that you should provide that puts you at risk. But it is a negotiated term. And the limitations on that, you can even have the limitations as it relates to infringement. So you may say that I will indemnify you up to $100,000. Or I will indemnify you up to X number of times of the value of the product. There's any number of things that you can negotiate as it relates to indemnification, so you limit your liability. So you just have to be careful in that regard, okay? Also, reps and warranties, again, going back to the point that was made earlier, you have to make sure that when you're licensing or granting a license to someone that you don't have encumbrances that prevent you from licensing what it is that you actually granted, right? Certainly if there's another owner, a joint owner, you certainly want to be careful in that regard. But the other things is that oftentimes startup companies will do what? They'll take out a loan, right? A business loan. And oftentimes that business loan has a security interest that's attached to it, and that security interest is attached to your intellectual property, right? And so if you are entering into a license agreement with someone, a licensee, a distributor, whomever, you need to make sure that you have fully disclosed what those encumbrances are, right? Again, a reason for termination of a license because you have misrepresented, right? But also potential lawsuit as well if you misrepresent that. And then also, obviously, if you're the owner of the IP rights, you have to make sure you understand who's going to maintain those IP rights. So if you file for a patent, right, you have to prosecute that application, and that there are certain fees that are associated with that, right? And so if you're licensing the technology along with the intellectual property rights, you have to continue to maintain that as part of your rep and warranty oftentimes, right? In addition to that, once you get a patent to issue, there are maintenance fees as it relates to patent rights. And so you have to pay maintenance fees even once that patent is issued. And you have to maintain those patent rights and be agreeable to doing so, in most cases under the rep and warranties. Yes?
Is it usual and customary for the licensee to guarantee, warrant, whatever, pursuit of the patent, pursuit of the IP?
That is
it's in their best interest, of course, because they're selling the product.
Oftentimes that is the case, particularly when you're dealing with small companies. You know, even in the university, you know, a large university, let's say they develop a technology and they license it to a licensee. That licensee oftentimes will say that I will pay for the patent prosecution for that technology in order to protect it effectively so that I can leverage this particular technology as the exclusive licensee, right? So oftentimes that is the case, and it certainly happens between small companies and larger entities as well. They are willing to do that. Now, oftentimes that's, again, part of the negotiation that goes on. So the cost may change based on them agreeing to pay for that cost, right? And they likely will demand exclusivity as it relates to the technology as well. So, which is reasonable. Patent exhaustion is another thing, is that you know, once you sell an authorized sale of a particular product, that person can do whatever they want to do with that product, right? That's a patent exhaustion principle. You have to understand that when you enter into a certain agreement and you sell a particular product to someone, that person now owns that product, right? And so now they can do whatever they want to as it relates to that particular product. So if there's certain things you want to prevent that from happening, then you need to put that in the agreement. Okay?
But there's unknowns, like, I don't know, I came up with smashing atoms and I license it to you and you're going to go make nuclear energy. And then you take a left turn and you say, you know what, bombs are the business billion. And all of a sudden you start blowing up people, right? As an idea, but nonetheless. So you take it in a direction that's not really a good one, as it were. But I couldn't possibly know that you were going to take my technology and turn it in that direction. I couldn't have predicted that within the agreement.
Right. So you're right. There are certain things you can't predict, and it's sort of like your example that you used earlier. I didn't envision people were going to use life-size figurines, right? Really didn't envision that. But what you can do is that you can limit the use, the field of use. In other words, you only can use it for this particular specific purpose. And so that's how you avoid that issue. So you limit as much as you can, and that's again part of the negotiation process, because obviously they're going to be pushing in the other direction. And as they push in the other direction, right, you say, well, we can do that, but it's going to cost you X, Y, Z more, right? And so there's that back and forth that occurs, right? And so that's how you do that. You narrow down your field of use very specifically to a particular type of use, a particular regional location or what have you, and then by way of doing that, that avoids that issue of not being able to anticipate what's going to come down the line, right? Because oftentimes, as an example, you say, well, I didn't really think this was an international product that was going to be distributed internationally, but it took off, and it's really an international product, right? So oftentimes, you start having those conversations when you are negotiating with a licensee, as an example, to say, okay, what regional distribution do you want, right? Do you want national, right? Ask that question. Do you want a national, distribution, or are you looking for international? Because it's a different price depending on what you want, right? And you start having those conversations very early on, all right?
What about 10 minutes?
10 minutes, okay. Sub-licenses, the main point with the sub-licensing chart is the fact that if you allow for sub-licenses, the sub-licenses have to carry the same terms as the primary license. You don't want to have contradictory sub-licenses. And if you don't want it sub-licensed to anyone, then you need to specifically say you don't want it sub-licensed to someone. That's the main point of that chart, okay? Royalty-based licenses, and we kind of talked about that earlier, so I won't revisit a lot of this, but one of the things you should just keep in mind, it doesn't have to be royalty-based, it could be fixed fee. Or it could be a combination of the two. You could say you pay me X amount of dollars up front, and then you pay me a royalty on the back end, right? And so it can vary. Now, what I will say as it relates to royalty, it is very important to make sure that you're saying a percentage of what. And you usually want it to be of the final sale that's made. of the product, right? Because there's a lot of monkey business that can go on in the accounting process when you're talking about royalties. So you just have to be careful in that regard. You say 5%, 5% of what, right? Is that final sale or what is it that you're talking about, right? Because oftentimes you can have, you know, Coca-Cola sell it to one of their subsidiaries who then sells it at a discounted price and then it gets sold to someone else, right? Well, okay, what sale are you talking about? Was it to their, you know, closely held subsidiary or was it the final sale, right? And so you have to be careful in that regard as well. Negotiations, get appropriate counsel. I always say do a term sheet first to kind of get some of that forecasting issue out of the way, to make sure you kind of have it laid out as to what your desires are. In other words, who's bringing what to the table and what are my terms is that I'm looking to achieve. In the negotiation stage, you understand the nature of the deal, who's bringing what to the table, who's taking what risk, and et cetera, that we covered on the first chart. And also one of the things that you also should consider is that oftentimes a negotiation for a license starts with a cease and desist letter. In other words, you have patent rights or you sometimes have some proprietary rights someone's using and you say you're infringing my patent. Well, if you send a soft cease and desist letter to some big behemoth, guess what? That can be considered an action such that allows them to now file a lawsuit against you. So be careful about and make sure you seek counsel and make sure that you understand that when you send your letter to someone, that can be considered a challenge and they can actually file a lawsuit and actually file a declaratory judgment against you to try to seek to get your patent validated in a court of law. Don't really want that to happen, so make sure you seek counsel in that regard. All right, trademark licenses, we talked about the branding earlier. You want to protect your brand, make sure you can control quality. You want to make sure that your products are clearly marked, that there are quality control provisions as it relates to that, and then when you grant a license to it, you want to make sure that you understand that you have the ability to do an accounting of that licensee, that you have the ability to examine their facilities, make sure that they're maintaining the quality and level that you desire, right? And you want to make sure that all that is built into your license agreement. Now, one of the things that if you try to maintain too much control over the licensee, then oftentimes it opens up the shelf for all kinds of other liabilities, one of which is product liability, right? So in other words, if you're just like in the knickers of that particular manufacturer, what have you, and you're doing all the quality control for them, guess what? If something happens with that product that causes damage to a consumer, then you may open yourself up for liability. So just be careful in that regard. Okay, let's get some questions if you guys have questions before we wrap up. I think we got about 5 minutes for questions. Yeah.
You kept mentioning counsel. Is it like a trademark and patents attorney, or
I'm sorry,
what type of attorney are you? Can you be more specific?
What type of attorney am I?
No.
Or what do you need to
seek counsel?
Seek counsel from, okay. Yeah, so certainly you would want to seek counsel from an intellectual property attorney, right? Oftentimes, depending on what your product is, right, and what it is that you're seeking counsel for, most intellectual property attorneys, you know, may do one or the other. They may do trademark only and copyright. They may do patents. Well, most patent attorneys have the ability to do the trademark and copyright as well. So I would start, as a starting point, you know, with an intellectual property attorney that has a patent background. And then if they are not the right person because you're really trademark intensive, then they will refer you to someone else. But that's where I would start.
So what type of attorneys do you work with if you're trying to like acquire like a manufacturing company, say like bankruptcy, or you looking at the attorney?
You're trying to acquire a company?
Like a company, yeah.
So most of the time when you're trying to acquire a company, you're usually looking at a corporate attorney that's looking at it. And obviously there will be a due diligence part of that. There could be an IP component to that, because that manufacturer may have certain intellectual property that creates value for that particular entity. And oftentimes
It's small, like unless it's small under like 5 million corporate.
Again, it's still made because there may be some proprietary process that allows them to do what they do, right? Exactly, and so oftentimes there's a significant intellectual property right that's involved there, and so you want to make sure that you have an IP attorney involved as well to do diligence in that regard. But generally speaking, it's a corporate attorney that would do the transaction for us. Yeah.
Patent lasts approximately 20 years.
I'm sorry?
Patents last approximately 20 years.
20 years was filed.
Right, which is fundamentally a 20-year monopoly. You know, granted, if your license agreement has a term shorter than that, and you come to the point where the license agreement has run out, the patent continues. The patent was not part of the license agreement. You just, I'm just licensing you, granting you the ability to produce that product, but not licensing the IP with it. When you come to that position, two things can happen. One, there's an automatic, let's relicense, and we renegotiate and have a new license agreement. The second is that lapse and nobody, because it's 10 years down the road and everybody forgot. They continue to produce. Now they're infringing upon your patent because it wasn't granted. And forget the licensing agreement, which is one problem, but the second problem is they're now infringing upon a patent. What happens in that case is you have two kind of problems. One is if they continue to produce and make profit off of the patent, that in and of itself is a natural thing. And if you don't go, now in theory they're friendly. They've been making you money all along the way. So I guess I don't have a fully formed question, but something along the lines of you have to defend your, if you show a history of not defending your patent, then all of a sudden that patent gets dissolved. So, not stopped, but it's lighter weight if you show a history of not defending it, but they're friendly. So, how can you call them to the table or get that resolved?
Right. So, okay. So there's a couple of issues that you kind of thrown into play there, and so let's see if we can kind of divide them up a little bit. One of the issues is that if you have a licensee that in the license term has expired, you still have patent rights though, and this person continues to produce the product and sell the product and make money off the product, right? And let's say, for instance, you are aware of it, but you do nothing about it, right? In those particular cases, you do have a principle of latches, whereby if you do that for a period of time, you may lose the ability to go after that person because you have basically said, I knew it and I didn't do anything about it, right? And that's about 6 years. By the way, Myers Deal is back there. He's one of my associates. I did bring adult supervision with me this time, so to kind of keep me in line. But he's one of my show associates, and so that's Myers Deal. So yeah, about 6 years is time for us. That's the one issue. But as it relates to your patent rights, I'm sorry, the license agreement, right? Certainly you can re-up the license agreement at any point in time. Now, as far as it's a friendly relationship, right? You can always go to the person and say, look, you guys have been producing for this time, and I'm willing to be agreeable for you to pay me a royalty based on the last negotiation, but now from this point forward, we're going to renegotiate, right? In which case, if it truly is a friendly relationship, that should go over pretty smoothly. Now, of course, you could be hardball with it and say, no, you guys did this, and so we didn't agree to a term. That term has expired. Now, you may think that that's reasonable, but I don't think that's reasonable anymore. I think you should pay me a higher royalty. Okay. Or pay me some fixed fee just for your craziness of doing this and not, and then you pay me the same royalty from that point. There's any number of ways to negotiate it, but it doesn't necessarily have to be a nuclear event, if you will. So.
But how do you think about the difference between the licensing violation and the patent infringement? Because there's two different questions here.
Well, okay, so when the license term expires, you really don't have a contract anymore, right? So it's not like they're
continue to produce and sell.
Right, so they're not really in breach of contract per se. So the license at that point really is not really relevant from that standpoint, other than the fact that it kind of sets out a set of facts and terms. It's the patent piece is the major piece now, because you're saying basically you're infringing my patent rights because you no longer have a license, right? That license is applicable just from the standpoint of saying, okay, what's reasonable? What do you have to pay me now that you continue to do this? And that kind of gives me a metric. We agreed to this in the past, so that kind of gives me a flavor for what you should pay me now as a starting point anyway in your negotiations for settling the issue. So.
Yeah, I'm kind of under the impression, just of what I'm dealing with. I'm a manufacturer, and I license other people's trade, right? So that stuff's usually pretty generic. Things like they've got that stuff pretty set, right? I don't need to have a lawyer go over there first, do I? Here's why I ask here.
I'll let Myers fill that question out. No, go ahead, I'm sorry.
Well, I work with Weirfield licensing and CLC to do related products, things like that. So I've just been under the assumption, which is why I think I should ask, I don't know what assuming that, but that their license agreements are pretty set in stone.
That is true in many cases. That doesn't mean you shouldn't look at it though, right? I mean, but yes, you're absolutely right. If you have a large entity that let's say you're making football gear or baseball gear for and using a lot of the NCAA logos for the different teams and the different branding that's associated with that, and they probably have a standard license agreement that they're using, and they're not going to be very negotiable in that regard. You just have to use your or don't do business with them. When they're doing business with the NBA, they may have a standard agreement, and either you do business with it or you don't. If you're doing a license with Google, they're going to say, take my license agreement or don't do business with me, one way or the other. And so oftentimes you do have that. That doesn't mean you shouldn't look at the agreement though, because there may be something in there that says, man, this is just really going to cause me issues later on down the line, and I'm not sure that I want to take on that liability. So you should at least look at it now, just so that you go in with your eyes open. And also, if there are certain requirements, right, from a quality control standpoint and et cetera, make sure you're not breaching that license. Because you're going your merry little way, then all of a sudden they find out something is in relation to your quality or your the marking or something that is in breach, and they say, oh, dude, I looked at your product, right, after doing this quality control, and you're in breach of my license agreement, and now you owe me money, right? And so, because you breached the contract. So you don't want that headache, is the bottom line. And so, yes, you're right. Sometimes it's just a standard agreement and it's non-negotiable, but you should make sure that you understand what's in that agreement. First of all, to say, I can't really accept that. I'm not going to do it. Or you say, okay, I'm making sure that I'm abiding by that agreement so I don't breach it and get into problems that way.
I did have another question too about, so for professional stuff, professional sports, MLB, they want you to, like MLB, you have to file, you have to apply. You have to $100,000 just to apply. So I'm trying to think of ways that I guess my question is, can the Cardinals grant me a license on their own without going through the league?
I don't know the ins and outs, so I'm not going to opine on them. And Myers may. I don't know the ins and outs as far as the MLB licenses as it relates to the individual teams. But my understanding is that there are separate arrangements that you can have. You can have a license with the MLB, but you also can have licenses with the individual team as long as they're not crosswise, right? So the Cardinals can't, again, we're talking about what you can grant, what you have the rights to grant. You can't grant something that the MLB prevents, right? And so, but there are probably certain things that the Cardinals possibly could license to you and not go crosswise with the MLB. That's just my guess, but I don't know the details. I've never negotiated one of those license agreements, so I'm not going to say. I don't know, Myers, if you have any other.
Yeah, I don't know. It could be dependent also on what kind of relationship the league has with a certain sponsor. So, the league may mandate that you can't contract with, Visa because MasterCard's a major sponsor of Major League Baseball, something like that. So I think it's probably just league by league dependent. It's possible.
How would that blow up? So let's say the Cardinals grant him a license to go do something, but they really didn't have the ability to do so. It blows up. Yeah. MLB comes after the Cardinals. Cardinals come after him, or MLB comes after him and the Cardinals at the same time.
The MLB probably comes. The MLB probably comes after him and the Cardinals, but they know the Cardinals have the deep pockets, right? Number one, but number two is probably the Cardinals' fault because they licensed something they didn't have the ability to do, and so he could, say, okay.
So now he's knee deep in legal fees just to say.
Yeah. So that's the reason why, again, you can not look at the license agreement and possibly run into some liabilities later, or you can look at the license agreement and make sure you go in with your eyes open. So I would suggest going in with your eyes open.
That's when you'd want to have like an indemnification clause also. Yeah. That would be a good thing for an attorney to look at.
Yeah, those Cardinals getting the license.
Hey, you were responsible.
Yeah.
You said I wasn't infringing.
Exactly. So.
We have time for one more question.
All right. Well, thank you for your time. All right.